Hello, everyone, and welcome back to Immigration Fridays. I'm Prashanti, your immigration attorney for this week, and we're tracking a question that's more critical than ever for your entrepreneurial dreams. EB-2 National Interest Waiver versus the H-1B route for founders, especially in today's tricky immigration climate. Look, for years, aspiring immigrant entrepreneurs have faced a tough choice. But with the recent H-1B proclamations and the new fees and the general tighter rules with reference to the H-1B, the scales have really tipped. Let's break down why EB-2 NIW is good for founders. First, let's talk about the big picture, permanent versus temporary. So an EB-2 NIW, that's a direct path to a green card. We're talking about permanent residency. It's the stability you need to truly build and scale your business without having to constantly worry about your immigration status and filing amendments and filing a self-petition. The NIW is a self-petition where no employer is needed. For a H-1B, you can file a self-petition, but you still need to file through a company. A H-1B is also used by entrepreneurs who are non-immigrant visa holders. It's temporary. It's usually for a period of 6 years. And you can do it through your own company, as I was saying, but you have to provide that there's a legitimate, you have to prove that there's a legitimate employer-employee relationship, which, let me tell you, is often a hurdle, especially for single founders or majority owners. It's very difficult to show employer-employee relationship. And after that, again, you'll have to file for the green card. So the first step for entrepreneurs is that when building a business from the ground up, certainly is essential. The NIW offers that in abundance. Let's discuss the Presidential Proclamation and the effect that it has on entrepreneurs, and then we'll come back to how an NIW can solve that problem for you. The proclamation, it isn't just headlines. It has a real world impact. For H-1Bs, we're seeing massive new fees. We're seeing figures like 100,000 just to file a new H-1B petition. And who can start that, especially if you're outside the country? How can you start a company if you have to pay that kind of fees up front? And we don't even know if the 100,000 is every year or they'll just keep it to 1 year, well, one-time fee. They're still figuring that out. And then there's the talk of raising the prevailing wages. If they raise the prevailing wage levels, that would mean that the startup will be forced to pay a significantly higher salary to you, the founder, even when capital is tight. The proclamation also increases travel restrictions, and there's a general uncertainty for H-1B holders trying to enter and re-enter the US. In addition, if we talk about flexibility and control, the NIW is definitely outshines the H-1B. With the NIW, there's no employer dependency. You are your own boss. You're filing your own petition. You can pivot your business, change your strategy, even find another company, incorporate another company without worrying about filing, H-1B amendment and without, it jeopardizing your status. On the other hand, in a H-1, you're tied to that specific employer, that specific job description. Any significant change with reference to work location or change in management or change in salary would mean that you'll have to file a H-1B amendment, which will again make you liable, because anytime you file a petition, it's an additional liability for you. Additionally, let's not forget the H-1B lottery. That's a massive hurdle by itself. which you won't have to face with the NIW. So for an entrepreneur, still agility is the key. NIW gives you that freedom to innovate without, immigration laws holding you back. But there are some disadvantages to the national interest waiver EB-2 category as well. And a significant disadvantage is, especially for Indian nationals, Chinese nationals, there is weight in the EB-2 category. Since the NIW comes under the EB-2 category, there is a very large weight. Other countries also are backlogged, but not as much as some, India and China, for example. So if you're outside the country, that'll delay your plans to start your business because you can't come in until your priority date becomes available and you are able to file the final steps of your green card and go for an interview and get approved. If you're in the country, you'll have to continue to maintain your non-immigrant status until your EB-2 NIW priority date becomes available. So in summary, if you're an entrepreneur with a venture that has substantial merit and national importance, and you can show that you're well positioned to advance that endeavor and that it would benefit the US to waive the traditional job offer requirement, which is a requirement, which is what the EB-2 national interest waiver is about, that's great. It's direct, it's stable, it offers flexibility you need to succeed. But of course, the disadvantage is the wait time. The EB-1 extraordinary ability category is much better than EB-2. EB-1 is also good for entrepreneurs if you have extraordinary ability. But every category has its advantages and disadvantages. For EB-1, the chances of getting approved are much lower because uh, the chances of meeting those requirements are very difficult. However, EB-1, as I said, the wait time is much less. EB-2, NIW, it's easier to get it. So as I said, advantages and disadvantages to each. So don't let temporary visa challenges or new proclamations limit your entrepreneurial dreams. If you think the NIW EB-2 is better for you, or maybe the EB-1 is better for you, consult with an experienced immigration attorney. They will assess your unique situation and they will advise you which route to take. And that's all for this Immigration Friday. If you found this helpful, please like this video, subscribe to our channel, hit the notification bell so you won't miss out on future insights. And don't forget to leave your questions and comments below. See you again next Friday. Bye-bye.